Hi, I'm Peter Mallouk. Welcome to 1,000 Miles from Wall Street. I'm here with Chrissy Knopke and Annie Rogers, two of our estate planning attorneys. Thanks for being with us. This is where you guys...
We're happy to be here.
We're happy to be here. I love it. Perfect.
Thanks for picking us.
And so what we're going to talk about today, I wish this was a 3-hour one. Okay, so what we're going to talk about today is healthcare documents. And there's two main kinds of healthcare documents, healthcare power of attorneys and healthcare directives, or what a lot of people call living wills. And Chrissy, why don't you start by telling us a little bit about healthcare powers of attorney?
So a healthcare power of attorney is a document that you use or is used when someone can't make their own medical decisions because of an incapacity. So it could be a temporary incapacity, such as car accident, where you arrive to the hospital unconscious but later regain consciousness, or it could be a permanent incapacity, which oftentimes is when we use them as people are aging through life. They're living longer, but they're living longer with dementia or Alzheimer's, which renders them permanently incapacitated. They cannot make their own medical decisions for themselves because they don't know. And so you literally nominate somebody else to make those decisions for you if you can't make them for yourself. And so you can put people in priority and to act consecutively. So most people will put their spouse and then back that up with a child or someone like that in case something happens to both spouses.
And by child, you mean adult child?
An adult
I'm just
child.
Thinking of my 13-year-old making that decision.
And I wouldn't even say an 18-year-old child, as someone who has reached majority age, can make that decision. They have to be mature enough to be able to handle removing someone from life support, because that could ultimately be the healthcare decision that they need to make.
That's right. And they've got to be comfortable making the decision and preferably name somebody that does not want you dead.
Correct.
Right? So
Yes.
it's something we always have to
So if you're 90
about.
years old,
Right.
your 20-year-old girlfriend probably shouldn't
It's
be
not
dead.
your healthcare power of attorney.
That is an important factor, though. A lot of times people choose that person based on whether they are in line with their views of end-of-life decisions.
Yeah, I think that's a great point, because sometimes people will name somebody to make a healthcare decision for them that doesn't believe in, say, quote, pulling the plug, right? But that's what they might want.
Sometimes they don't even name their spouse because they're like they never would pull the plug or they'd pull it too soon. You know, and we kind of laugh about that in what we do, but it is a factor when people are making those decisions.
Or we'll have clients that will nominate someone that's close to them in the medical field because they understand what's happening during that end-of-life situation.
That's right. And a lot of people don't realize healthcare powers of attorney also covers some things just like switching someone from a doctor to a doctor, or a hospital to a hospital, or a nursing home to a nursing home. So I think it's great. I know that the two of you, that every single person you meet to do an estate plan, you automatically do one of these for them, because every single adult should have one.
Right. And something to keep in mind that I tell all of my clients is, once your kid turns 18, they get in an accident, they're just like an adult. The hospital won't be able to release information to you, and you wouldn't be able to make their medical decision for them now that they've reached 18.
We actually had a case with an advisor here where this client I worked with personally, her daughter got in a car accident coming home from the university and was life flighted. And the most horrific thing for the family, thankfully the girl lived after not being on life support for a week, was the family could not make the healthcare decisions because she was 19.
And the judges don't find those things to be emergencies. They'll put it on a regular, 2-week out docket to get you some guardianship or conservatorship over someone's estate.
Most people are surprised by that, and they go, wasn't it obvious that the spouse would make the decisions, or the mom or the dad? And I think the court's opinion is, you've got your own rights. This is America, and if you wanted someone to make the decisions for you, you would have taken the time to get somebody to do it.
Exactly.
And Annie, I know a lot of people sometimes will use a living will instead of a healthcare power of attorney. Can you walk us through the difference? Because a lot of people think they're the same thing, and they're not.
They're not. In some states, there's an advanced directive where they can kind of combine the two together. But the living will is really about the end-of-life decisions, and they're really kind of based off of some of the Supreme Court law, like with the Terry Schiavo case and things like that, where families were not in agreement with what to do in that case. And so a living will basically says, if I'm in a permanent vegetative state or I have a terminal condition and death is imminent, I don't want to be kept alive artificially. And that includes things like nutrition, hydration, blood pressure medication. There are ones that are a little bit more generic that way. And then there's something else called an advanced healthcare directive. And some states have these, some don't. Some states have statutory forms that where you initial, I don't want this specific thing. Like if I am in a permanent vegetative state, I do not want surgery or antibiotics or dialysis.
Right.
And it says that this would be if these things are not going to improve my condition. So if, you could do it, but it's not going to change the fact that you are in a permanent vegetative state or save your life. So most people initial all of those things because it's really kind of it's not going to help things at that point. So.
Right. And I think I consider that document to just be a much more dangerous document because we really don't know what we don't know. And I'll just share a personal example. My mom had a stroke. She was at the hospital. She had a healthcare power of attorney. And I went to the hospital. My dad's laying in a bed. And I said, I thought it was my mom that had the stroke. And they said, it is, but your dad fainted when we told him. So I said, oh, this isn't good because he's the doctor. Thankfully, he came too. But the doctor had said, go ahead. She's going to be in a permanent vegetative state. You should pull the plug. And thankfully, we're all emotional, crazy people. And we said, no, let's give it that 1 in a million chance. And she's walking and talking and 100% here and vacationing. And it's 13 years later. And so I've always really viewed those living will, those healthcare directives very skeptically, and I've always encouraged my clients to give that authority to somebody else who can look at your values, your beliefs, like Chrissy was saying later, the totality of the circumstances, Annie, like you were talking about, and you pick somebody who shares those values and knows you, and they can make that decision for you. But everybody listening should have one. If you've got adult kids and or parents that are still with you, if you're fortunate enough to have them with you, they should have them too. You guys are fantastic. Thanks a lot.
Thanks, you.
Peter.
This commentary is provided for general information purposes only and should not be construed as investment, tax, or legal advice. Past performance of any market results is no assurance of future performance. The information contained herein has been obtained from sources deemed to be reliable but is not guaranteed.